do not be arrested and be locked in a police cell if your offense is going to be fined. It is illegal to arrest anybody and detain him in a police station if the offense he's facing is one that is to attract a fine. 2, if the offense will attract an imprisonment of less than 6 months. The OCS of Central Police Station, one Chief Inspector Judicial Angoya, has been arrested. The reason being that he released protesters who are protesting over fuel price increases. Very many of them were arrested and taken to Central Police Station. You know very well, Central Police Station seems to be the only police station with a jinx. OCS Talam is in detention, prison, awaiting his trial over the brutal murder of Mwalimu teacher Albert Ojwang at Central Police Station. Yesterday, after the demonstrations, the CS for Interior gave a huge number of over 300 protesters having been arrested. So when these people were arrested, they were taken to Central Police Station because Central Police Station is a gazetted police station. It has cells for male and female. Once they were booked in, the OCS released them on cash bail or on personal bond. What we need to know is that, number one, Kenya does not have a law on bail and bond, that is police bail and bond. Parliament has failed to make that law. Therefore, the OCS is the only mandated person with the powers to decide case by case whether to release a suspect, somebody who has been arrested before he's taken to court, on bond or bail. The police bail is not known by law how much it is. But the following offenses, the OCS, they are the only offenses the OCS is not allowed to release anybody on bail by law. 1, treason. Anybody who is arrested for trying to overthrow the government of the Republic of Kenya or hurting the President of the Republic of Kenya is charged with the offense of treason. That one, the OCS has no power to release. 2, murder suspects. Anybody arrested for the offense of murder, the OCS has no power under the law to release that person. 3, anti-corruption offenses. Any offense falling under the Economics and Anti-Corruption Act, the OCS has no power to release. Any other offense other than those 3, the OCS has power to release. 2, the OCS is the one who, anybody who has been arrested, the OCS must be satisfied that the condition of that person is good for him to be booked in the OB. All OBs, before a prisoner, what they call a prisoner in police language, is booked in, the OCS must approve that that person is being booked. 2, before a prisoner is, that is a prisoner as they call them, we call them suspects, but the police language is a prisoner. Before a prisoner is released, either to court, it is the OCS who must sign the OB for that prisoner to be released. Before he is released to go home, it is the OCS with that discretion. Number 3, the OCS has powers after listening to the circumstances of each person who has been arrested to order his release. The circumstances can be, 1, a mother who is lactating. The OCS will order that mother to go home and breastfeed the child. 2, somebody who is ill or has been assaulted and has injuries. The OCS will order the release of that person to be taken to hospital. 3rd, a person who is unwell. The OCS can order that person to be released to go and be treated in the hospital. 4th, a petty offense. Offenses that are petty. And this one is a constitutional provision. I know many Kenyans will be shocked that this is the Constitution speaking under Article 49(2). Listen, while you are aware of this, only OCS, Judicial, Angoya knows this. What does the law say? A person shall not be remanded in custody for an offense if the offense is punishable by a fine only. If you have offense, you are likely to be fined. The OCS has no business to keep you in police custody. Or it goes by imprisonment for not more than 6 months. That is the Constitution in Article 49(2). No Kenyan is supposed to be arrested and be kept in police custody if the offense that you are going to be charged with is an offense that is finable, that you are going to be fined. These are offenses like all traffic offenses, or petty offenses, or misdemeanors. The misdemeanors are cases that you are not going to be jailed for more than 3 years. Those offenses are finable. So today, from Court Helicopter, you now know the law. Do not be arrested and be locked in a police cell if your offense is going to be fined. 2, if the sentence provided for that offense is below 6 months. So the OCS, after listening to the people who were arrested, the probable offenses they were going to be arrested, to be charged with, was creating disturbance or obstructing motor vehicles from moving or stopping movement of motor vehicles. These are finable offenses. I have seen the charge sheet, that the offenses that they have been charged with. Many of the offenders who were arrested have been charged under Section 58 of the Penal Code, which says obstructing the operations of vehicles on a road contrary to Section 58C of the Road Act, Cap 48 laws of Kenya, where the punishment, the fine, is less than 5,000 shillings. So the OCS was right to deny the orders from above. Yes, the OCS has to comply with directions of his bosses. He takes directions from the OSPD. The OSPD, if the OSPD gives illegal orders, the OCS has power to refuse. Remember, police officers are only to obey lawful orders. The lawful orders are lawful in terms of, are they known by law? The OCS looked at Article 49(2) and found out that these offenses, if they are taken to court, they will be fined and they will be released. Number 2, The OCS knows very well the right to picket. Article 37 of the Constitution of Kenya. Very many Kenyans have been arrested for maandamano since the time of the late Raila Amolo Odinga. I know I was part of the team that defended very many of the maandamano people, including Waziri Opiyo Wandayi, including Senator Sifuna, all the people in ODM. I defended them, and they were charged with this offense. The likes of Babu Owino, the likes of the Nairobi senators, the Nairobi MCAs, all members of parliament from ODM were arrested, and I defended them. Over the offense, these charges were dropped by the ODPP. The OCS is aware of all this, and that is why he released these people. Number 3, did the OCS assess the security of keeping these people in police custody? What if the demonstrators came and entered and ransacked or rained down Central Police Station? It's not the first time. A police station, when Albert Ojwang was taken home, a police station in his home village was run down. Very many police stations have been run down when they have kept protesters behind bars. The OCS should be recommended for having, 1, understood the plight of the Gen Zs, 2, looked at the security of the police station and the lives that could be destroyed if protesters stormed into the police station and attempted to free. How many people could be dead today? How many people have been shot dead whenever protesters try to free people from lawful police custody? From court helicopter, we now have told every Kenyan and every OCS in this country, read Article 49(2) of the Constitution. And that is, anybody who's arrested and who is going to be fined should not be arrested and be put in police custody or in the remand. 2, if the offense attracts an imprisonment of 6 months and below, that person should not be detained before the courts have said it. Let us look at the case that decided this matter. To get perspective, a similar matter in the High Court at Kenya at Kisumu County, Kisumu High Court, case number HCCR REV/E006 2026, Maximilian Motai Nyagwaya versus the Republic. Here we have a decision by Justice Omido sitting, Justice Omido Mkutu sitting in Kisumu. What is the proceedings in this matter? It says, the court ordered that the applicant remain in custody at Central Police Station Kisumu until it delivers its reserved ruling. As we have seen above, Article 49(2) expressly prohibits remand in custody for the offense if the offense is punishable only by a fine or by imprisonment for not more than 6 months. There is no two ways about it. The order went against the constitutional provision. I need not say more. The judge therefore proceeded and said, the applicant shall therefore be released forthwith from Central Police Station, Kisumu, noting that no criminal charges have been preferred against him unless he is otherwise lawfully detained. The court further directs that the lower court file be closed with no further action to be taken in respect of the application for custodial demand, as it should never have been entertained in the first place, given the constitutional provision under Article 49(2). Justice Joe Mukutu Omido faces a judgment coming from the Kisumu High Court. What is the import of this matter? One, it is illegal to arrest anybody and detain him in a police station if the offense he's facing is one that is to attract a fine. Two, if the offense will attract an imprisonment of less than 6 months. Chief Inspector Judicial Angoya is our hero today from Court Helicopter. On the grade of 10 to 10, we give him 10 to 10. On the question of illegal orders supplied by his bosses, he cannot obey lawful orders. Unlawful orders, those are the police standing orders. Okili, Dan Omari, wishing all the best for Judicial Angoya, the OCS, who has stood and defended the Constitution. Article 3 of the Constitution says everybody has a duty to defend the Constitution. Angoya, the OCS, has defended the Constitution, and every organ of government is bound by the Constitution of Kenya. Not arbitrary orders from the CS, from the DIG, from the IG, from anybody. Judicial has stood and brought honor to the profession, to the police officers who are loyal to the Constitution of Kenya. Wakili Dan Omari.